All right. Well, we'll kick off in just a moment or two. We'll just give people a minute to join the call. All right. Well, good afternoon, everyone, and welcome to this webinar from the Canberra Business Chamber on changes to industrial relations law through the Closing Loopholes Bill. Thank you so much for being here and for joining us. If you don't know me, I'm Greg Hartford, the Chief Executive of the Canberra Business Chamber, and I'm joined today by Olivia Perry, who provides us with lots of fantastic advice for managing those tricky WR issues. It's been a big year for industrial relations so far here in Australia, and it's fair to say that the rate of change shows no sign of slowing down. We've seen a number of legislative changes come into force. They are going to impact every employer and every workplace in the country, and there's been a new heightened era of compliance resulting from that. You will, as employers, need to exercise greater caution and be ever more careful of what you're doing to make sure that you're complying with the rules and with the changes. But don't worry too much, because today we're going to unpack some of the details, or at least Olivia will unpack some of the details. Just before I hand over to her, I just do need to give you a little bit of a disclaimer that the information we're about to give you today is simply a general overview of what's happening and represents our views provided in good faith. This workshop does not constitute legal advice, so if you do need legal advice, or you're dealing with a specific situation or issue in your workplace, or have questions that are specific to your business, please do reach out to us via our Employer Assist hotline, and Olivia and the team will be happy to help. So Olivia, I'll hand over to you. Look forward to hearing what you've got to say, and I'll come back at the end and manage any questions. If our attendees do have any questions, please just use the Q&A function at the bottom of your Zoom screen, and we'll get to those at the end. Thank you.
Wonderful. Thank you so much. So yeah, I'll just be working the slides, so please be patient with me as we go along. But just for today, we've got a lot to cover. There has been quite a lot in 2023 and 2024 inclusive for this closing loophole changes. So as you can see here, we'll be going through a few of the major ones, including the right to disconnect, the new definitions for the types of employment, wage compliance, the union powers, and the new protections for employee-like workers. So I'll go into a little bit more detail about what that means, as well as the bargaining changes as well. So there's a lot to get through, so I'll quickly skim through. So just a bit of an overview of what has actually happened from 2023 to 2024, so almost now. As you can see, there has been quite a lot. So that 4th of September was the initial closing loophole legislation amendment, up until now, where we have had that second part of the closing loophole receiving royal assent. As you can imagine, there may be some changes still continuing throughout this year in regards to the practical standpoint of a lot of these. So we won't have any discussion over those changes that could potentially happen or anything in regards to those, but basically, this is a bit of a rundown of where it has come from the beginning until the end. In regards of a brief overview, pretty much in that early December, the government did strike a deal with the senators, along with the Greens, in relation to their agreement to have that bill split into the two of through those legislations of the Closing Loophole 1 and Closing Loophole 2. As you can imagine, it was quite a large change to businesses. So we did have a lot of questions in relation to them from our line. But basically, don't feel as though you need to write any of these down or anything. We will be sharing this, and obviously this is recorded. So please feel free to just listen in if need be. Apologies, it's just taking a minute. There we are. So one of the larger questions we have been getting from a lot of clients is this new right to disconnect. So we'll be starting it off here. Again, as I can imagine, probably one of the most controversial changes. And one of the biggest changes that has been quite recent as well. So we'll quickly touch into all of that. So in basic terms, and the intention of the right to disconnect is that if an employee is or has the obligation or eligibility to ignore messages or communication sent to them outside of working hours, so long as that behaviour is not unreasonable, they also cannot be punished for any of those not answering calls or messages during those working hours. Now, we're looking at the intent of that. There is obviously out of hours or being on call allowances for most awards. So we do assume that in best practice, those will be disincluded or not included from the right to disconnect. But essentially, it is just adding that element or intent that someone doesn't need to be sitting on their emails or sitting on their phones or sitting on text and being able to log in at any moment. They have their working hours, and those don't need to be exhaustive outside of their contact hours. A question we have still been getting quite a lot is, can I still contact my staff outside of these ordinary hours? Yes, as mentioned, you can. That isn't the intent of this right to disconnect. Realistically, you're looking at the fact that you cannot punish your staff for not responding to that. So, as a working example, if somebody was working Wednesday night, emailed their employee, if that employee didn't respond until Thursday during their working hours, it'd be unreasonable to discipline or take any action in relation to that. When we're looking at that reasonable contact outside of that, there is again, non-exhaustive at this stage, list of what would be considered reasonable. So some of those being the reason for the contact or attempted contact. Again, if it's something that is a safety or well-being concern or anything along those lines, that may fall out of that unreasonable status. How the contact or attempted contact is made and the level of disruption. So a simple text may be different to multiple phone calls consistently throughout the night. The extent to which the employee is compensated. So again, where I'm looping back at that on-call allowance as well, there may be examples where that does not constitute that right to disconnect. The nature of the employee's role and the level of responsibility. So again, managers may be within that inclusive reasonability. And also the employee's personal circumstances. So allowances such as family or caring responsibilities, if the employee is very aware of their caring responsibilities potentially, it will affect that reasonability as to the contact. Obviously, as you can imagine, a lot of those do dive into further questions. So in practice, this will be a difficult one to navigate, I dare say. But again, feel free to call that helpline for any further understanding of that reasonability. And what I always do like to say is look at, with that reasonability that always comes up in legal terms, look at it from a third party perspective or look at it from your own perspective. If you would feel that it would be unreasonable to receive a call at 10 p.m. for something non-urgent, then it may sit in that unreasonable circumstance. Apologies, sorry. So we did just look at that unreasonability, apologies, but these are just these examples again here. So whether it's reasonable, it does apply to all employees. So that will encompass casuals as well, to note. And when we're looking at the general protections claim elements as well, this is that protection where essentially an employee is found to have been terminated because they did not respond during a reasonable time period or unreasonable time period, that may bring elements of general protections claims forward in that termination process. As you can imagine, the Fair Work Commission will take queries or concerns in relation to this, and employees and employers are able to discuss that right with the Fair Work Commission. Again, the Fair Work Commission will have a test element. Again, we are still working through that at this stage in regards to that test. But again, just making sure that you're looking at that reasonability in that response or contact at all times from this stage onwards. Okay, what does this mean for your business? So again, I think the important part is to look at that intent behind the right to disconnect. So consider the forms of the outside working hours currently that you use in your business, and whether these could be claimed as unreasonable. Again, looking at it from that third party perspective, would you see that any contact that your business is currently doing as unreasonable? If yes, you may need to look at navigating or changing that. Again, managers and key decision makers in an organisation should really educate themselves on this right to disconnect. Should you be going back to the business in discussion with this, potentially have that discussion with all of your key decision makers to make sure that there aren't any claims that can be brought against the company from an employee. Additionally, managers should be using technology for their advantage in regards to rosters, which are going to be quite a large element of this right to disconnect. So some examples, as I've mentioned before, on-call rosters. A suggestion may be using an app to allocate for those workers in relation to shifts coming up. Outlining at the bottom or the top of an email, whichever your preference is, that there's no expectation for the employee to respond all outside of their working hours is a really easy way for the business to distinguish when the employee does need to respond. Or scheduling an email to send during the employee's working hours may be something as well. But I do think out of this, a really big summary, the best suggestion is to have at the bottom of an email for all members of your company that there is no expectation for employees or even clients outside of the workplace as well to respond outside of their working hours. Further to that, another best practice element may be to create policies or guidelines which establish that right to disconnect. So making sure that there's really transparent workplace expectations regarding the out of hours contact, and that can be really highly regarded within management as well. And such guidelines should really clearly state the circumstances and methods through which out of hours communications for employees should occur. Again, that's where we may have more on-call allowances being held. Or simply a different way to manage, such as shifts allowances for an online roster of some sort, potentially. At a minimum, such policies and guidelines should really make clear to employees that they're not obligated to monitor or respond to unreasonable out-of-hours contact. Some staff may feel as though they have to be sitting on their emails or have their emails on their phone to respond to at any time, even if the manager potentially prefers during flexible working to work outside of their rostered hours. I think just having a conversation with all staff or making those policies that if an email comes through outside of your working hours, there is no obligation for you to respond. When we're looking at compliance in regards to reviewing or updating employment contracts as well, for those not covered by an enterprise agreement or some sort of modern award, their contract can simply just state their annual salary does compensate for all reasonable and additional hours. Generally, that is called what we call it a set-off clause, essentially, and that can only be applicable if the employee is, again, enterprise agreement or modern award free. If they are covered by a modern award, it does become a little bit more complex, as you do need to pay above the award rate in order to have that reasonable and additional hours compensated. So please just keep that in mind. Again, just please keeping in mind in regards to that right to disconnect, the allowance or the compensation of a higher rate of salary doesn't mean that an employee needs to be online 24/7. It may just be in the example potentially where a manager may need to roster for the next shift or next day, something along those lines where an on-call allowance is compensated within that salary. So something along those lines, again, is quite niche. So please call the line if you have any questions in relation to that as well. When you're setting those clear expectations from the beginning with clients as well, some people may be in a role where clients can continuously call even when outside of their working hours. So I think trying to set up policies or practical measures with clients as employers to make sure that they're aware of this right to disconnect is quite important. Potentially, if you do or are aware of clients who do tend to call outside of those working hours, potentially having a blanket email that you send to those clients noting that not all staff will be monitoring or reading their emails and responding to them after hours, or having potentially someone who does respond during those out of hours is really important to make sure that the employees don't feel as though they're forced to respond in those periods where those clients are, maybe stressed or requesting an urgent response. So we'll sort of move down. I can understand if you've probably got more questions for that right to disconnect. It is a really popular one, but more than happy to touch those at the end of this webinar. I will look now at the new definitions for the types of employments though. So we're going to be looking firstly at casual. It is kind of, again, redefining, but looking at the previous definitions as well. So as you can see here within this new definition that we've highlighted, you're reverting to the position where basically the reality of the employment relationship is that they are casual in nature. Again, the case that was reviewed was the High Court decision called Rosato. Within that case, it was basically where a long-term, regular and systematic casual with a very clear contract of employment stated that they were casual had been changed basically through this decision of the court into a permanent employee. It was decided the casual wasn't really a casual in nature. And the High Court in that decision then determined that there was a need for a greater precision or understanding of those direct focus on the terms of the contract. As such, within these, when looking at from an employer perspective, the verbiage or the wording I do like to use is, if it looks like a casual and sort of maneuvers like a casual, then you can feel quite safe that it's a casual. But if something where they're working quite regular and systematic hours, you can look at a roster and really define what they would be working through next. In reality, they're sort of more looking like a part-time employee. That is where you need to start looking at this reality and change of a casual and focusing on whether you may need to change them into a part-time employee potentially. Sorry. So again, further looking at that definition of casual, again, as I mentioned, we have kind of returned to a situation where a person will be a casual if the employee relationship, is characterized by an absence of a firm advance commitment to continuing and the indefinite work, and the employee would then be obviously entitled to a casual loading. So again, that point of the consideration or the real substance behind it is that practical reality and true nature of the employment relationship, not the employment contract. So even though the employment contract may say that this employee is a casual, if that casual, again, systematically really looks as though they're more of a part-timer based on their shifts, their rosters, their role, all of those elements, then again, you would be focusing more on the fact that this employee is most likely not a casual. So I'll just look at the previous definition. So the previous definition noted that a person is a casual employee if they accept an offer from a job or from an employer, knowing that there is no firm advance commitment to continuing with indefinite work according to that agreed pattern of work or that roster. Now we're looking at that new definition. So noting that is from the 26th of August, 2024. The employee is a casual employee only if, firstly, so looking at number one, the employment relationship is categorized as no advance commitment to continuing or indefinite work. Number two, the employee is entitled under an award or an enterprise agreement or even contract of employment to be paid as a casual loading and that specific higher rate for casuals. And then further, in determining whether someone is a firm advance commitment or continuing to indefinite work, we need to look at a couple things. So firstly, that real substance, so that practical reality and true nature of the employment relationship. So really focusing down on that intent of the relationship. Is there potentially an element where the employer is purely having this person on as casual so that there's that inevitability that they may terminate if need be? And if such, again, would need to focus on whether that person is really a casual in regards to that role. Further to that, we merely need to look at whether there's a firm advance commitment in the form of a mutually agreed term or contract in the employment agreement. So in addition to a mutual understanding or expectation of the employee and employer, it can mean that how the employment contract is written or performed, including the conduct of an employer and employee in entering into that agreement, can infer a firm advance commitment of shifts. Sorry, I'm going to switch. So then looking at, again, that new definition of casual, the following can pretty much indicate a firm advancement or commitment. So whether there is an inability of the employer to elect to offer work, or an inability of the employee to elect or accept or reject work, whether having regard to the nature of the employee's work, it's reasonable or likely that there will be future availability in continuing of that work. So again, looking at the role, is there a substance that they may be continuing shifts or a continuing similar roster? Again, mainly to look at whether that employee is actually casual or not. Further to that, looking at that role again, are there full-time employees or part-time employees performing the same kind of work, but in a full-time or part-time commitment? If yes, is there a reason as to why this person in this exact same role is a casual? May need to look from that perspective. And as always, this has been quite similar in regards to that casual conversion right, but is there a regular pattern of work for that employee? Yes, this doesn't have to be, absolutely uniform. It can fluctuate from time to time, such as if there's an illness or injury in the business and they just need to cover a couple of shifts, for example. That doesn't mean that they're not, that full-time or that regular and systematic, but essentially, is there that regular performing shifts where, there may be an assumption that you could look at a roster and create that assumption of their next shifts. Again, can be a consideration. Noting all of the considerations that I have noted, just because one isn't satisfied doesn't mean that the rest of them aren't satisfied, and it doesn't mean that you need every single one to be determinative in order to have that right to no longer be a casual. It may just be potentially that there's an element of that regular and systematic, for example, and that can be enough to create that part-time or full-time equivalent amount. Just noting with the legislation, it does make it clear that a regular pattern of work does not in itself indicate a firm advance commitment to continuing for that indefinite work. So basically, a casual employee who has a regular pattern of work can still be a casual if there's no advance commitment to continuing an indefinite work. As an example, that may mean that the role can be for only a short period of time or a project potentially, and that may be the reason as to why the employee is casual. So again, something to note, that regular and systematic doesn't always mean that there needs to be that transition. I do understand that some of these are very broad, such as that reasonable future or ongoing work. For full-timers and part-timers, that can mean that there aren't future work potentially. But again, these are kind of drafted in a way on purpose to just have that intention to assist casuals who want to elect or be able to change to permanent. And I think when we're looking at this element, we just look at that intention of, should this role actually be casual? And when we're looking at those decisions, look at those purposes of a reasonability as well. So in regards to, I guess, how does this new definition impact you exactly? It doesn't mean that everyone that you employ as a casual needs to be moved to full-time. There isn't anything that forces those casuals all of a sudden. Again, I think just making sure that we're looking at the intention of the legislation and the intention of everything I've discussed in regards to those steps. I think just having a review of the company is enough to know whether your casuals need to stay casuals or that new definition will affect them in any way and need to make that change. So not all new casuals will need to be transitioned to full-time or part-time, apologies. But all new casuals will need to make sure that they fit that new definition following the new legislation that has been coming through. So how does a casual become a permanent employee? So for that transition, casuals don't automatically, as I've mentioned, shift into those permanent employees, which is just taking a while to load. Thank you. Employees also do have the choice if they would like to as well. And just to cover off, unless a casual satisfies the relevant tests I've mentioned and actually chooses to become permanent, they don't have to change or move from that casual. The new casual conversion choice process, basically when we're looking at the old system, at a certain point in time, you had to offer permanent employment and the employee would be able to choose to take up this offer or not. This is now altered. So the new most popular part of the reform, as you can hear, is that it's now been streamlined and employers no longer have to offer once the section at that 6 months time period for larger employers. The new process basically is that a casual employee can issue a written notice to the employer if they would like to change their employment status to full-time or part-time. If the employee believes that they no longer meet the definition of casual and they have been employed for a period of 6 months at the time of the notification, or 12 months if you're a small business employer. An employer has 21 days to respond to this written notification. And then before providing a response, employers are required to consult with the employee about the notification as well. So making sure that you're having some form of discussion, whether the transition be to move them to permanent part-time or full-time or keep them as casual, it's important to have that consultation. If accepting the notification and moving the employee from casual to permanent, it's generally not a straightforward process. You would need to have discussions around and in that consultation around whether they would like to be full-time or part-time, their exact hours of work, because again, being a casual doesn't mean that automatically because they've got set days and hours, that's what their transition to permanent full-time or part-time will be. And basically just making sure that once they create that contract and sign that new employment contract, you and the employee agree on your days and hours that will be their permanent roster. I'll now look at the options for declining. So the options for declining are a little bit more limited than previous, but basically, and in summary, it is going to be more difficult to decline. Again, we are looking at that fairness and reasonability assessment. So when looking at that, doesn't necessarily mean that, again, there's a straightforward answer. It is quite broad. But again, we would need to look at the fairness and reasonability, as I've mentioned earlier, as to whether the role actually is required to be casual. And again, looking at those standpoints, again, I would discuss with one of the helplines at any stage. We are helping you to discuss as to why you would be declining and whether that's a reasonable term for that. So again, what does this look like for your business? So we'll just pull all of that up. Apologies, sorry. So again, casual employment statements. I do just want to quickly touch on that. Employees, when you are sending an employment contract to them, are obliged to be receiving a casual employment statement. There is a new one. It's on the Fair Work website. Fairly easy to find if you just import the casual employment statement, but you are required to send all of those to all of your casuals. Basically, as you can imagine, it is a little bit complex, so please feel free to call the line. But basically, there is an obligation to tell your employees about their employee choice for this changement. So basically letting them know on commencement, after 6 months, if you are a large business, and after 12 months, if you are a small business, that they do have that eligibility to request that they can change to a permanent role should they wish to do so or they have the right to at least discuss and consult about changing to that larger role. In best practice, it may be the best idea to have a blanket email that you send to your staff, and having a notification within your system that on commencement they receive that casual information statement. And then again, depending on the size of your business, a small business is anything smaller than 15 employees or less, again, including all staff, casuals, full-time, permanent. But having a notification that sends around that casual information statement again, so that you're complying with those regulations. Casual contracts, making sure that you're reviewing those casual contracts to make sure that you're updating any terms which may indicate a firm advancement or a continuing definite work process. And again, I would definitely suggest having a bit of a casual employment audit. So looking at all of your roles, making sure that you don't have some roles that are permanent and some roles that are casual, and making sure that the management and those key directors are looking at all of those casual employment, and making sure that they are actually continuing or non-continuing, and looking at that reasonability as to whether you should be transitioning or at least offering for those transitions to a more permanent role. So I'll now be moving along to the employee and employer definitions that have come through. So I will just pull up the definitions there. Sorry. So while the Act mostly talks about rights and obligations of employees, it's actually never had a definition of an employee as being anything other than its normal predetermined elements or definitions within court. So the Act has now included a definition for employee and employer, which are determined by the reference to the real substance, practical reality, and true nature of the relationship between the parties. So as per the casual changes, this did occur following a contract-centric, I will say, approach from the High Court decision in a case that noting personnel contracting and JAMSEC. So in that decision, for the High Court further held that there was comprehensive written contracts that exist, and questioned whether an individual is an employee of is an employee of a person to be determined solely with the reference to rights and obligations found in terms of that contract. So basically, the High Court further held that it's not necessary or appropriate to engage in a wide-ranging review of the parties' conduct in performing their obligations under that contract. So again, essentially, it's no longer the law to determine if someone is an employee or an independent contractor, and it will require the totality of the relationship between the parties to include not only the terms of the contract governing the relationship, but also the manner of the performance of the contract. Imagine that probably sounds a bit confusing, I'm sorry, so I will discuss it a bit more. So again, we are kind of reverting to the old way again. So we're returning to that multi-factor test for employee versus employer, and that independent contractor allowment. So whether an individual is an employee or an independent contractor can really have significant impact on the rights and entitlements for the Fair Work Act. And I will note as well, it can have some harsh tax entitlement concerns as well. So it's really important that we're really looking at this factor test to make sure whether someone is meant to be an employee or that independent contractor. So the new definition for employee and employer will only apply under the Fair Work Act. However, the approach of determining the status of the worker through looking at the contract will apply to other workplace laws again. So superannuation, workers' compensation, long service leave, the list goes on in relation to leaves and employees. So it does sort of come hand in hand in regards to those concerns. So there can be an issue when looking at following situations, because you can no longer rely on the terms of the contract to determine an employee or an independent contractor. It does cause a few issues in regards to businesses that have contractors integrated into their employees. Potentially anyone who has low-skilled contractors, or where the contract and the reality of the contract are misaligned. So if your contract says things that don't reflect the practical reality, you may likely need to accept the fact that you cannot rely on that contract like you have in the past. So just slide, sorry. Again, employees versus contractors. So when we're looking at back payment quickly, the back pay for unpaid entitlements will not arise for workers who were previously contracted under the old version of the Act and will change in status to employees as a result of the new amendment. However, for such workers, employment liabilities have started accruing from the 27th of February 2023. So that is noted, apologies, that is noted on this slide. So just keeping that date in mind. The opt-out notices. So one of the more difficult changes to the Fair Work Act is that introduction of the ability for an individual to opt out of the application of the new definitions, and as such remain subject to the approach flowing from those High Court decisions. So to break that down a bit more, a person may give an individual, the contractor, a written notice stating that the individual may give them an opt-out notice if they consider their relationship may become an employment relationship due to this change. An opt-out notice can only be given to a contractor whose earnings exceed the contractor high income threshold, noting that high income threshold does change consistently from the 1st of July, much like other wage changes, as you're aware of. So making sure that you're looking at that high income threshold if you are looking to have an opt-out notice in any way. So again, to loop back, what does this all mean? I think when looking at the review of independent contractors, again, it is really important that we're looking at the ATO aspect of that. So making sure that you're having a review of all current independent contractors in your business to assess whether they should be considered employees. Further to that, obviously, you can then look at that high income threshold to see if any feel as though they would sit under that opt-out opportunity. When we're looking at those arrangements for the engagement of those highly paid independent contractors, if you are looking for an opt-out mechanism, I would suggest that you give us a call and make sure that the opt-out mechanism or clauses that you're putting in place are relevant and protect your business as a whole as well. Again, when looking at those independent contractor arrangements or those templates, when looking at the split between contractors and employees, it's very important to make sure that you're looking at it from a perspective of the entire employment. So rosters, the way they pay, receipts, whether they have any subcontractors, whether they potentially have tools or allowances that they utilize for themselves. And I think with that intention, making sure that you're really looking at the intent of that role. Should that role, again, be an independent contractor, or is it just an independent contractor because the employer is hoping to have less obligations as they would as an employee? So it's very important that you're having that high level discussion of that reasonability of the contract in all. So wage compliance. So I'm just going to, slide across. So I'm going to look firstly at the same job, same pay obligations. So this was originally a change that basically Company A had an enterprise agreement. Company B was providing labour to Company B. However, Company B couldn't pay its employees less than rates in Company A's enterprise agreement. There was a massive campaign against this change. You may have seen it in the newspapers or on the TV, but basically this section of the bill was changed somewhat following that. Basically, if you are engaging a labour hire provider and they're coming into your business, and you have an enterprise agreement or even potentially a modern award covering the work that you do, it is not that you have to pay the labour hire people the same. There's an obligation that basically the application of this is regulated labour hire arrangement orders that the work is to be paid the same as what is within your enterprise agreement. So obviously, as you can imagine, this has become quite an issue for your labour hire concerns, or those who do have labour hire workers. But basically, there just is a fairness element to make sure that if you are working the same job, whether you're from a labour hire company or not, you should be receiving the same pay within a company. Fairly self-explanatory for that one, as you can imagine. Just go further into this one as well. So when you're looking at a genuine contracted service, if again you're using a labour hire that meets shifts in demand, so more sporadically, it is a true genuine labour hire need, you'll be fine in relation to keeping that. If you're using labour hire as a secondary workforce and you have again an enterprise agreement or a modern award, that is where the loophole is asking you or seeking the employer to close that, and you may be capturing this change for an order by making sure that there isn't that risk of the incorrect payments being made. For those using labour hire as a core part of the workforce, and it would be an enterprise agreement covering the work, the labour hire they are doing, you should be taking steps to prepare for a possible regulated labour hire arrangement ordering change. The Fair Work Commission determine whether it should make an order or not. They make a regulated labour hire arrangement order if it's satisfied that it's fair and reasonable to do so. And there's a range of matters that they'll be considering in relation to this. So some of those being the pay arrangements that apply to employees of the regulated host, and therefore the regulated employees, the history of the industrial arrangements applying to the host and the employer. So an older enterprise agreement may result in the Fair Work Commission looking at this in a different reasonability. The relationship between the regulated host and the employer, so including whether they have regulated related bodies incorporated included within that, or whether they're engaged in a joint venture or common enterprise. Further, they will look at whether the performance of the work is wholly or principally to the benefit of the joint venture or the common enterprise engaged by the regulated host. And some of the terms or the nature of the agreement terms that they will be looking at will be the period for which the engagement operates, the location of the work being performed, the industry of the work being performed, number of the employees. So again, they may look at a small business differently to a larger business, and any other relevant considerations potentially. We don't have any clarification on that at this stage. So one of the questions that may arise is when is a contract for service, which is excluded as opposed to a labour hire. So the Fair Work Commission cannot make a regulated labour hire arrangement order unless it's satisfied that the performance of the work is not or will not be for the provision of a service rather than a supply of labour. So when looking at that, they will have regard to the involvement of the employer in matters relating to the performance of the work, the extent in which the practice of the employer or the person actually on behalf of the employer directs the employees to be regulated during the performance of their work, the extent to which the regulated employees use or will use systems, so maybe plant structures in relation to the work performed, and the extent to which the employer or another person will be subject to that industry or professional standards or responsibilities. So again, looking at that industry. They'll further look as well to the extent of the work is a specialised or expert nature. These are all basically just things that the Fair Work Commission will take into consideration when looking at this contract in regards to the labour hire extent. So looking at this wage and super theft now. Apologies, just having a slow computer. Alrighty, so as you can imagine, underpayment of any wages is a civil liability offence. And in some limited cases, it can also now be held as a criminal liability offence as well. So those criminal liabilities will only apply to intentional underpayments. So if somebody, through genuine mistake, accidentally or inadvertently underpays their employees, generally that won't be held to a criminal liability and simply only a civil. It is only when there is that intent that is there. So in regards to that criminal standard, it is anything that is beyond a reasonable doubt. So that is in relation to that burden of proof for that criminal standard. So in saying that there is a proof of burden beyond reasonable doubt the employer intended for their conduct to result in a non-payment of the employee's standards. So those statutory standards under the Fair Work Act, Modern Award Enterprise Agreement. So with that intentional, so when we're looking at those acts, it obviously does come down to basically done on purpose, deliberately, consciously, and that is found by the beyond reasonable doubt standard. So within that as well, the legislation does refer to an employer failing to pay the required amount, which results in an intentional failure to pay the required amount to an employee on full. On or before the day when the required amount is due for payment. So they may look at the payment for your pay days as well. And that does include wages and superannuation as well. So that is limited to the number of employees for whom superannuation is applied for, and can include elements such as long service leave, paid leave, that can be domestic violence leave as well, jury service leave, emergency service leave, those elements too. So when we're looking at the penalties, where a person is guilty of committing 2 or more offences for these wage penalties, the person is taken to have found guilty of a single offence. So just noting that quickly. So I'll just look at those penalties now. Sorry, it's just loading the next page. There we go. So when looking at those increases, the civil penalties will be increasing from the 93,900 to the serious contraventions of the larger amount there, as you can see. Serious contraventions for recklessness, when looking at that, they no longer exclusively pertain to intentional acts. They encompass reckless behaviour as well. So employers are at risk of being deemed reckless when their payroll team, legal department or directors are aware that their payroll systems are insufficiently compensating employees in relation to awards or enterprise agreements as mentioned, and they failed to address the problem. So as an example, if your payroll alerted you that you were underpaying as an employer, that can be held as that serious contravention and can be held at that maximum penalty of the $939,000 as well. When looking, there was obviously a High Court decision overturned in relation to that proportionality for civil penalty proceedings. So this now means that the maximum penalties are not reserved for only the worst case scenario. It can be just looking at that consideration of the deterrence for the protection of public interest as well. So in saying that, the High Court can decide that, yes, you know, this scenario isn't the worst case scenario in that contravening conduct, but they are just wishing to deter other employers from acting in this way. So that penalty can be utilised for the encouragement of the compliance of the award. So keeping that in mind as well, they may not look at that reasonability of the intention of the overpayment as well. So moving to sham contracting. So when looking at sham contracting, we specifically look at 357(1) of the Fair Work Act. Basically, that outlines an employer must not make representations that an employment relationship is an independent contractor arrangement. So I did touch on this a little bit earlier in relation to sham contracting, but we're now looking at the engagement of sham contracting and the rise of civil penalties should you be engaged in that sham contracting. Again, looking at that intention, As per section 357(2) of the Fair Work Act, a defence to sham contracting may be that the employer just had no awareness or did not know that they were intentionally sham contracting in relation to an employee, in relation to an independent contractor being an employee, apologies, and was not reckless as to whether there was an employment relationship as well. So again, kind of didn't take advantage of the person in question in that changes as well. So when looking at those changes to the defence, a new defence will apply if the employer proves the burden of proof remains within the employer's situation, that at the time of making the representation that they reasonably believed that there was an independent contractor arrangement. So again, I will loop back to what we discussed before. If people such as your payroll or your legal representative or your HR department was letting the employer know that there was a risk of sham contracting or there was sham contracting occurring, that may alter, obviously, your defence in relation to that as well. When looking at the closing loopholes changes, the defence from a subjective defence based on the employer's knowledge and recklessness has been moved to that objective defence, so based on the assessment of reasonability of that no knowledge as well. The size and the nature of the employer's enterprise is only mandatory consideration for the Fair Work Commission in some examples. So when looking at the employer's skills and experience, the industry, how long has the company been operated, the absence of a designated HR or industrial relations team or contact, and whether the employer sought to have an understanding through legal or professional advice for the proper classification of the employee versus independent contractor as well. So all of those elements can come into effect in regards to the understanding of that reasonable knowledge as well. So moving through to independent contractors. So at this stage, the Independent Contractors Act 2006 does cover disputes about service for contracts. The changes under the Acts change this or pass this jurisdiction for those under that high income threshold I mentioned earlier to the Fair Work Commission instead of that Independent Contractors Act. So again, that intention is to make it a far lower cost for independent contractors to bring up whether there may be sham contracting for the employer. When we're looking at the contractor, so what if a contractor does earn above that high income threshold? So where the contractor's annual earnings is above that high income threshold, the existing Independent Contractor Act provisions will apply, essentially. So you would be looking at the Independent Contractors Act 2006 instead of that Fair Work Commission when looking at those discussions for the independent contractor. So some of the workplace relation matters that may apply should they be under the Fair Work Commission are things such as your remuneration, leave entitlements, hours of work, disputes between employees and employers. Things further to that may be, superannuation, workers' compensation. The list obviously goes on for a while. When will a term be considered unfair? So an unfair term is where the Fair Work Commission is satisfied that a term between the contract of the parties is unfair if the relative bargaining power of the parties is unfair in nature. If the contract as a whole displays a significant imbalance between the rights and obligations of both parties, whether the contract term is reasonably necessary to protect the interests of the parties, whether the contract term imposes a harsh, unjust, or unreasonable requirement on the party. So those three words are something that do come up quite often in the Fair Work Commission and the Fair Work Act. Those harsh, unjust, and unreasonable. Again, with those terms, you do need to look at the reasonability of that. So there isn't an exact definition into what is harsh, unjust, and unreasonable, but the Fair Work Act does define those briefly. So again, further, they will look at whether the contract as a whole provides for the total remuneration of the employees for those minimum standards, potentially under your enterprise agreement or your Fair Work Act or modern awards as well. So how does the Fair Work Commission determine if a term is unfair? The Fair Work Commission is empowered to conduct conferences or hearings for an application, and that does have the ability to dismiss applications to make costs applications as appropriate. They will look again at that reasonability and further at those other elements of that harsh, unjust, unreasonable for all clauses within the contracts as well. So the small business redundancy exemption. So essentially with the redundancy process, if you are a large business, again, that above 15 employees in total, there are differences in relation to how you can handle your redundancy process, as well as redundancy pay as well. So the small business redundancy exemption is basically that small businesses are exempt from having to make a statutory payment under the National Employment Standards in the Fair Work Act. So that's redundancy pay, not notice pay, to your employees in a redundancy process. That does mean that during a bankruptcy or a liquidation process, an employer who may gradually downsize its workforce, meaning that the final employees who have their employment terminated may become employed by a small business employer, which is previously not a small business employer, can lose their entitlement to statutory redundancy pay. So as they grow smaller and start removing roles and employees through the redundancy process, they then become a small business employer. So with those new changes, that has carved out that with the small business exemption, it's been introduced in employers who are not initially a small business employer, but gradually became one over a 6-month period due to bankruptcy or liquidation. Process cannot access that small business exemption. So basically it's just protecting those employees, that if they were the process of that smaller liquidation process, they can still receive that redundancy should their employer have been a larger business. So we'll now move to wage compliance. Just a bit of a summary here. So again, what should you do to prepare for this? So obviously those criminal offences that I discussed are, quite scary in nature, but making sure that you're looking at any, or you are aware of any underpayments. So something to really look at firstly is, are you covered by any modern awards? Are you covered by an enterprise agreement? If yes to either of those, you should be looking at any kind of wage tables, as well as any classifications of staff that you currently have. Again, you're more than welcome to give us a call for any of those. But once you're looking at those initial elements, it can be quite easy to confirm their classification, confirm their salary. And when looking at all of those as well, I would highly recommend that you look at rosters and allowances as well. So things such as overtime, an on-call allowance, a first aid allowance, anything within those modern awards that you may have, looking at those and making sure that there is nothing that could be pulled up in regards to an underpayment. There are some companies that do audits on your companies as well. So something where you may look at auditing your entire company, maybe something you might like to look into. But basically just preparing for any of those underpayments so that you are aware of them is quite important. Further to that, if you are using any labour hire companies, making sure that you're looking at the wages and making sure any labour hire staff are paid at the same applicable amount as well. That may be something that you do following a full company audit of your wages to make sure that the wages are actually up to date. But looking at any labour hire is obviously of high importance. When we're looking at those unfair contractor terms, obviously it can be quite difficult for those to be aware or to assess those. So again, you may wish to have an audit on your employment contracts, or make sure that you're using new contracts which are completely legally compliant. So that may be something you reach out within the CBC to have those new contracts updated as well. So union powers. So with these new right of entries for unions, basically it's just a new ability for unions to obtain an exception certificate from the Fair Work Commission to waive the minimum 24 hours notice of entry. So previously there was a minimum standard that they needed to provide 24 hours notice. There are now exemptions, or there's an exception certificate that the Fair Work Commission may give to unions to allow for that to be waived. Generally, this is something that probably isn't too much of a concern to employers. I dare say unions don't tend to come through that often. And if they do, generally that 24 hours notice prior isn't too much of a concern. But it is just something to be aware of when you are allowing that right for entry when we're looking at those union elements. The Fair Work Commission can issue that exemption notice if they are satisfied that there is potentially a suspected contravention or contraventions that may be coming up within the business that involves the underpayment of wages or other entitlements. So again, looking at that underpayment of wages element, if you are paying all of your staff at the relevant modern award or standard amounts, this won't be too much of an issue for you, basically. But should the union member feel as though that there is those contraventions of a business, they can have this exemption certificate to immediately come into the workplace, essentially, and discuss with employees. When we're looking at the obligations of permit holders, this is not something that has been really altered, but just a reminder about the obligations. Union officials having that right of entry need to provide the occupier, so the employer of the business, the permit holder. You can search that online as well. There is an online website that you can search the permit number and confirm that the permit is of date and correct as well. In relation to permit holders, they can only enter workplaces during work hours. They're restricted to only accessing member records. They must not intentionally hinder or obstruct any person from exercising their rights. And they must only use information or documents obtained for the purpose relating to an investigation for a specific underpayment contravention. Further to that, they must not enter any part of the premise used mainly for residential purposes. So should that be the case, they obviously cannot enter the residential areas. So what happens if a union official misuses their rights? You can obviously make a complaint or have discussions with the Fair Work Commission for future conditions. But again, this isn't something that generally comes up too often. So just further, so with these new workplace delegate rights, basically the most relevant one is who is a workplace delegate. So there's delegates and there's union officials. A delegate is the employee that you have who has been elected to or authorised by the union to be a delegate on your worksite. So these are different to union officials and their rights are quite different in regards to delegates versus union officials. They don't turn into a delegate with union rights officials as well. The definition is intended to be sufficiently broad to capture those workplace delegates across a range of unions, regardless of the language used to describe the role in each union. The point of it basically is to get more union members and union delegates on work sites. That's the intent of these changes, essentially. However, it's important to understand that everyone for these changes doesn't mean that you have to have a workplace delegate. And you don't have to invite the union onto your worksite or elect a delegate because of this change. It's simply just defining both of those elements for you. So just looking further at these terms. It's just loading for me. There is more on the slide. So there again was a test case that came forward for this workplace delegate rights terms. And it basically, again, just gave us more guidance on the reasonableness of access to paid time off, those sort of elements. So when we're looking at those workplace delegate rights, this is under an enterprise agreement. So there's an access period. So if the employer has asked employees to vote on an enterprise agreement before that date, the term must be at least as favourable as the clause within any award that would otherwise apply. And if the term is not as favourable as any aspect of the award clause, then they will need to revert to or change that clause. Basically, it must be in all enterprise agreements, even if you don't have a union involvement in your workplace, which means that you have to explain to your employees why you are putting into that next bargaining round that change clause. If you fail to provide a delegate with their new rights and entitlements, basically the Fair Work Commission can have damages and penalties that flow through with liability from these provisions. So you do need to give delegates their generic rights and entitlements. So again, unions just become a little bit stronger in relation to this relevance. It's worth considering which union and understanding which union applies to your employee organisations and what rules they have entitled to represent their workers. Basically, again, just looking at those union delegates and those rights, they are the same within the entire country, and they have access to all of those elements of being able to look into any kind of underpayments, as I've mentioned. Sorry, just next slide. So obviously looking a little bit further now at those employee-like workers protections that have come into them. We are getting towards the end, just to let you know, so you won't have to hear my voice too much longer. So this legislation increases the rights of certain independent contractors, specifically those performing digital platform work. So a really good example of this is those Deliveroo, Uber Eats performers. So when we're looking at those digital platforms that are covered, or what is a digital platform, basically there are gig platform providers that are clearly covered by this change. So the type of businesses who might have delivered to you through Uber Eats are a really good example. Definition is basically broader, so it'll likely cover providers who operate off digital platforms as well. So it might not be as obvious as your Uber Eats or Deliveroo ones. So basically with this, there is a regulation on employee-like workers performing services. So it's defined a digital labour platform to mean an online enabled application website or system operated to arrange, allocate or facilitate the provision of labour services. It further goes into elements, so where the operator of the application, website or system engages independent contractors directly or indirectly through the website or system, or acts as an intermediary, for or on behalf of that distinct but independent set of users. It goes into a little bit more detail, but basically I will move through to who is covered. So it'll be to be covered under this, the worker must personally perform all or a significant majority of the digital platform work performed under the services and satisfy one or more of the following. So there's 4 allowances here. The first one being the person has low bargaining power in negotiations in relation to the services that they perform. The person receives a remuneration at or below the rate of an employee performing comparable work. So when looking at that comparable work, obviously they will take into consideration the industry, reasonability, the role, etc. The person has a low degree of authority over the performance of the work as that third element. And the fourth one being the person has such other characteristics as prescribed by the regulations. It's a little bit broad in relation to that one. But basically, when we're looking at this, you're kind of basically looking at anyone who is can be taken advantage of, essentially, in these independent contractor elements. So if you're feeling as though those independent contractors are creating a lower bargaining power for them in comparison to them being an employee, that's where you may need to take consideration for these. So minimum standards. So the Fair Work Commission has the power to create these minimum conditions for people operating on service platforms. These can be minimum standard guidelines. So they're a guide for what only, but for what they should do, or it can be given for minimum standard orders which are enforceable. So much like a modern award, as you can imagine. So on the left-hand side here, you can see we have identified some things that can be in those orders. So the critical one for the yes side is probably cost recovery, I dare say, in regards to all of those yes elements. If we're looking at the no column, obviously overtime rates, rostering arrangements all kind of come within that cost recovery as well. But work health and safety matters are of crucial importance as well. So following 2023 and the inclusion of 2024, they have upped the standards of work health and safety quite dramatically to be more encompassing to make sure to protect the employee. So it is important that we really look at those work health and safety standards for independent contractors as well as employees. When we're looking at general protections as well, so general protections are to define a little bit further within the Fair Work Act, and they basically protect the employee from any protected attributes under the National Employment Standards should an adverse action be taken. So the general protections regime has been expanded to include adverse action taken by a digital labour platform with respect to an employee like workers. Within that, the definition of the industrial action under the Fair Work Act extends to digital labour platforms and covered by those under a minimum standards order. I'll just pull up the rest of the slide. So, apologies. So when we're looking at collective agreements, the part of the Act here seeks to provide equivalent mechanisms for enterprise bargaining for employee-like workers, so still looking at that employee-like workers element. The intent of these proposed reforms is to enable a process where the employee-like workers are able to negotiate collective terms and agreements, essentially. So this builds upon the introduction of minimum standards for such workers as well. A digital labour platform operator may negotiate a collective agreement with the organisation. And again, that promotes or represents employee-like workers in relation to the terms and conditions for that platform. The Act also sets out a process for varying and terminating registered collective agreements. So a person who contravenes a term of that collective agreement is further liable for a civil penalty, much like other areas as well. So we will just look at unfair overview here. So there is that new ability for the Fair Work Commission to arbitrate disputes for unfair deactivations. Again, just looking at that digital labour platform code that has been newly introduced, there are remedies which further compensate, if need be, for that unfairly deactivated. Basically, when has a person been found to be unfairly deactivated? Within the definition, the person has been unfairly deactivated if each of the following is met. So firstly, the person has been deactivated from a digital labour platform. The deactivation was unfair. And the deactivation was not consistent with the code. So obviously with that, it is quite broad and you would have to look further in relation to the code itself. But again, so if something like this is occurring within your business, I would suggest that you give us a call and we can discuss a little bit further because it can get quite complex. So bargaining changes. Sorry, just pulling everything up. So with one-sided arbitration of bargaining disputes, the system introduced this probably just over a year ago now, arbitration to resolve intractable bargaining dispute. So it was effectively brought in as an alternative to the right to terminate an agreement. So the rule for arbitration is you have to be bargaining for at least 9 months after you commenced bargaining or the agreement expired, plus conciliation in the commission has failed. So there's no reasonable prospects of reaching an agreement. The party can then apply to the commission to arbitrate for any outstanding issues, and the commission would then make a merits-based decision as to the outcome of these outstanding issues. So the rules state that a non-agreed term must be less favourable to each of the employees who will be covered by the determination than a term than an existing enterprise agreement that applies to the relevant employees that deals with the same subject matter. In effect, employees can't go backwards on a line-by-line assessment of what they already have under an existing agreement. So this change is designed to move the risk of employees going backwards on any term that appears in the enterprise agreement and removes a significant point of leverage for employers in negotiations. With these changes, the agreed terms clarification also reduces the capacity for employers to wind back on the agreed terms post the making of the intractable bargaining declaration application. So one is a little bit of a complex one, apologies. Again, really only comes into consideration if you do have an enterprise agreement. May not be a lot of you here, but something again that you may wish to discuss through your HR or your provider when you are going through any of those enterprise agreement bargaining processes. I've spoken at you for a very long time. Apologies, and thank you so much for listening in. I know it's a complex one, so really thank you for listening in.
Olivia, thank you very much for your time this afternoon. It's been a really comprehensive briefing, and I know everyone on the call will have appreciated the depth that you've gone into. There's just one question before we wrap up, and that relates, I think, right back to the right to disconnect, which you were talking about at the start of the call. So to confirm, you can still contact your employee out of hours, but you can't necessarily expect a reply. Is that right?
Yeah, correct. Or discipline, basically in relation to not replying as well.
But there would be very few employers out there in a practical sense who are disciplining their employees for not replying to a text on a Sunday afternoon, right?
In a practical sense, yes. So I think the right to disconnect does sound quite scary. And we've gotten a lot of questions about it. But, you know, in theory, if you're having your workers do your classic 9 to 5 and all of their generic work in that 9 to 5, you're pretty well protected from it as well.
There is just one question that's come through, noting that a lot of businesses work in a fairly flexible way these days, and while you might have a sort of a contracted arrangement to go from 8:30 to 5, the reality is office workers especially often are quite fluid in that, and they'll take morning teas and they'll take lunch breaks and perhaps go a little bit beyond the contracted time. What's the quid pro quo for that, and how is an employer supposed to know if someone's actually on duty or not?
Yeah, the on duty part is difficult. In practical sense, you know, you want to be able to have that flexibility for workers, especially, you know, following COVID with all these remote workers coming out as well. So again, best practice may be just to have, again, that outline within an email that you don't have to respond in a timely manner, and, you know, people are working flexibly. Potentially just having, you know, touch bases if people are working or you're aware that they're working quite consistently outside of hours, or you know, making sure that even if those flexible hours, you're still having a set time where they're logging off, and you're making sure that they're logging off during that period as well. I did touch base at the start on set off clauses too. So checking in that, again, you're non-award covered, it won't be relevant, but those award covered employees are either being paid potentially overtime if need be, or they're looking at overtime if they're award covered, or they're being paid above the award standard as well. Just because that flexibility can obviously, if you're award covered, lead into potential overtime as a concern.
Excellent. All right. Look, if there's no further questions from anyone, Olivia, I'll say thank you very much on behalf of the Canberra Business Chamber. It's been great having you here, sharing your insights with us. We will make this recording and the slides available to members who want them. So it should be hitting your inbox sometime in the next day or so. Thank you very much, Olivia. Great to have you.
Thank you.
Thanks.